where we covered ESI, gratuity, maternity, and other benefits that have already come into force and are applicable from 21st November 2025, except PF, which is expected to be notified separately. Therefore, employers must align themselves with these codes effectively from December 1st. So, this transition is extremely time sensitive. For your reference, all our presentations and FAQs from previous sessions are available on our website, which is karmamgmt.com. And today we will be conducting the series with the remaining two codes, the Industrial Relations Code and the Occupational Safety, Health and Working Conditions Code. I am Dhanasvi Mistry from the advisory and research team at Karma Global. And joining me today are Mr. Pratik Vaidya, our Managing Director and Chief Vision Officer, and Ms. Sadaf Khan, our Head of Legal and Advisory. And as we move today through today's session, Ms. Sadaf will take you through the Industrial Relations Code and Mr. Pratik will take you through the OSH code. Over to you, Sadaf.
Thank you so much, Dhanasvi. And welcome back, everyone. I hope the last two sessions were very informative for everyone. And today we'll go on with the remaining two labor codes. So these are the important ones also. And one of them is the Industrial Relations Code. So I'll give you an overview of the Industrial Relations Code, which was released in 2020, and what happened, why it was enacted, and which all act does it covers. So first, let's understand why the code matters now. So, first of all, it's one of the codes which replaces three major acts. First of all, being the Trade Unions Act, the Industrial Establishment Standing Orders Act, the Industrial Dispute Act. All of these would combine together to help the workers, the employees, the people in the factories, establishments, the bigger enterprises, the ITES companies, and all of these different segments to be covered into one single code. So one of the major things is it has a very broad impact, that it helps on the unions, it helps to get the discipline, the to get a proper formalized way of getting the layoffs, retrenchment, closure, the dispute resolution across factories, services, ITIS, logistics, hospitals, and more. So this is one of the four codes, and it works in harmony with all the other codes. So that is the code on wages, the occupational safety and health OSH code. Then we have the social security code also. So it's all into and harmonized and all, and it works together. So just for example, the definition of wages, it's common in all of them. The definition of industrial establishments has been common in all of them. Now, there won't be a dispute whether an industrial establishment is considered under ID Act or if the same will also be the same in the industrial establishment standing orders. So it's more harmonized and more clarified now. So let's understand what the code replaces and what was the scenario before it came into force. So first we have the Trade Unions Act. So it was released in 1926. The main objective was that the union registration and rights, they are all codified and they get it all properly. Accordingly, there was one more act that was released in 1946, which is the Industrial Employment Standing Orders Act, and wherein the service rules for larger establishments were developed for the conditions, working conditions, because Factories Act has the basic parts like what they need to do, what they don't need to do, how an establishment needs to go on, provide safety and everything. Whereas the main part of how many hours of work needs to be there, how many leaves, and every basic details, which will be a model format that will be there, as well as a customized list that will be there for every single factory and establishment. So this was the main act that governed it. Then we had the Industrial Disputes Act. So Industrial Dispute Act, as very well a lot of you might be aware of, is a very vast act, and in that it relates to any and every single dispute relating to employer, employee and employer, and worker and worker. So all of this was there. The definition of workers, employees, everything was codified and clarified in these things. So now IR code made a point to codify them together because all of these three acts were in consonance with each other. So one of the main parts that they introduced along with these three concepts that were there in all of these acts was the negotiating union councils. Earlier, there was no specific negotiating union or council as such. There would be multiple trade unions, and accordingly, they would come together and have a collective bargaining session. Whereas now, the scenario is different. So, in just in a few minutes, I'll give you an understanding on what the negotiating council or the unions are. Then we also have a new concept, the grievance redressal committees. So earlier, whenever there was a dispute, it would directly go to the HR maybe, or else directly if the employee is not or the worker is not happy, they'll approach the labor code. And accordingly, the burden of the labor code was increased drastically. So in this part now, because of the grievance redressal committees, these burdens on the labor courts have been reduced drastically, and we'll even get an understanding what does this committee do, or basically the composition and stuff like that. Then we have the unfair labor practices. Earlier also we did have a lot of unfair labor practices which were codified and realized. The similar things also there right now on this code. We also have a new concept called as the reskilling fund for retrenched workers. So there was already a retrenchment compensation that was given to them. Now, along with that, there'll be a reskilling fund to help them find re-employment. So, and one more major thing is that though the existing union standing orders and awards cases, they all will continue and they will stay the same unless and until they're repealed later on. Right now, the saving clause clearly mentions all of these awards, even these three acts, as long as it is in, it's not inconsistent with the code, it will still remain. So let's take a look on the coverage now. So in the definition, first of all, who all are covered in it? First, we have the industrial establishment or the undertaking. What is the industrial establishment? So the code clearly clarifies that it is an industry wherever a place and industry is carried on. So it includes manufacturing industries, factories, mines, plantation, transport undertaking, and docks. It also notifies something plus commercial establishments. So in commercial establishments, it also covers the service industry, the hospitality industry, the ITITS industries. And now the scope has become even more wider than it earlier was. Then we have the definition of worker. So let's understand the difference between what an employee is defined as and what a worker is defined as. So employee is a much more broader and wider scope wherein skilled, semi-skilled, unskilled, manual, technical, managerial, administrative, all of these people are considered. So any person who is providing all of these services or hired for these reasons, they will be considered. But it is very important to note that apprentice, specifically whoever's covered under the Apprentice Act and is considered an apprentice, will not be covered in any of the codes. They already have a separate legislation as the Apprentice Act, and they're not covered in this code. Whereas the definition of worker, let's get an understanding who a worker specifically is. So, a worker is a person broadly defined who is employed in an industrial establishment to do manual, skilled, technical, operational, clerical, and supervisory work for hire or reward. Now, the definition is on more of nature what they do. So, one of the main exclusions also are there that primarily engaged in managerial or administrative capacity, they won't be considered. And specifically, any person who's on a supervisory capacity or a managerial capacity and drawing wages up to 18,000 will not be considered as a worker. Whereas in the definition of an employee, there is no such exclusion in this matter. And if anybody is earning 18,000, they won't be considered. In employee, they all are considered. Whereas for worker, 18,000 is the maximum limit here in a supervisor or managerial capacity. And then we need to understand who are the employer or what do you mean by an employer. So it refers to any person who has the ultimate control of the establishment or the affairs of the establishment. So in a factory, it might be the occupier. In any other establishment, it will be the manager or the managing director or the whole-time director who appoints and manages the affairs of the main establishment. It makes sure to get the accountability to a person who is identified as an individual or an entity who is responsible for the entire management of the establishment. So let's understand by practical examples. First of all, in a manufacturing plant. So maybe in a large manufacturing plant, there are 300 employees. Clearly illustrates the distinction between like production line workers, the quality control technician, administrative clerks, junior supervisors. These all will be considered, and they're all earning under the 18,000 and they will be considered as workers. Whereas the plant manager, the head of human resources, the senior engineers, the senior supervisors, and all. they will be considered as they won't be considered under the definition of worker. Whereas the plant manager, the person who will have the entire control, will be considered as the employer. So now take one more example, that is the software development firm. So consider a tech company having more than 500, 600 employees. There'll be multiple software developers, testers, then there'll be IT support staff, there'll be cleaning staff, there'll be administrative staff. Now, all of these guys will be categorized ideally as workers if they're earning up to 18,000. If somebody on a supervisory level and all earning more than that will be considered as an employee here. Whereas the person who will be the main head, that would be the managing director or any active director, whole-time director who's there and managing all of this stuff, or the CEO, they will be considered as the employer in this specific scenario. Then let's take an example of a retail chain outlet. So in large retail stores, the sales associates, the cashiers, the stock room staff, they all workers were allowed to have the as an employer. So, as I've already mentioned, one of the main important consideration is not ideally what their designation is, but what their role is. Like, for example, in a maybe in an outlet, the person who's a cashier is already at a manager or a senior manager level, but there is a store manager who might be he domination may be the store manager, but he might be having on his CV or the actual badge that he is a man, basically vice president or something. Even on that cases, the vice president here, who is the store manager and having the complete authority over the store, will be considered as an employer. So this is very important to understand because these are main topics that comes up whenever there's a legal dispute. So let's understand now who's the appropriate government. Now there are different type of appropriate government. First we'll have a central government. The second part we'll have a state government. So which all industries come under them? First of all, the central government considers railways, major ports, mines, oil fields, central PSUs, banks, insurance companies, notified establishments. Okay, so this is one of the polls now. I've already given an introduction on that. So, which of these three acts do you think, or which of these options are the ones that are covered in the IR code? Okay, now let's understand let's get back to this, the appropriate government part. So, these, first of all, the points that I've already mentioned, they're covered under the central government, whereas which industries will be considered under the state government? So, most of the private factories, they're all under the state governments. Hence, the state rules will be applicable to them and not the central rules. Though it's a central code, the state rules will be applicable. Whereas logistics hub, IT park, offices, large shops and commercial establishments, service sector units, all of these are governed by the state government. So why it matters? Because depending on whoever is the appropriate government, accordingly, those rules will be applicable. And in case of any dispute, similarly, you can approach the appropriate government on that part, or is the appropriate redressal forum. So let's move on. Now, then we have the headcount threshold and the definition on the establishment, industrial establishment. Now, industrial establishment is already defined. Now, what is the headcount or a threshold here? Normally, for getting a standing orders to be applicable on your establishment, earlier it was that 100 workers are required in an establishment for the standing orders to be applicable to you. And accordingly, you'd have to either take up a model standing orders as soon as the act becomes applicable to you. And if you do wish to personalize your part, then definitely you would have to draft a standing order on your part, whichever points you need, and the entire process is to go. And it would be submitted to the officer. And accordingly, once it is clarified, the certifying officer would give it back to you, and that will be published in the establishment on when you're on any of the conspicuous places or the notice board or some bulletin board, and that will be the main working hours, the leave conditions, and every single thing that relates to their working and their benefits. So one of the major things that we need to understand is, so this 300 worker column. So what do you mean by 300 workers? Does it mean that there's one establishment like for example, XYZ? XYZ is a company or an industrial establishment. Total, they have 1,000 employees. So 1,000 workers. So in this case, though they have 1,000 worker, they have four different plants, which is on one plant has 180 employees, one has 280 employees, one has 310, and the other has just 80 employees. So would all of these be covered? No, only and only the only plant which has 310 employees, which is 300 or more than 300 employees or workers specifically, will be covered under the standing orders. So specifically for that plant, they will have to either get a model standing order, and after that, if they do wish to get it certified and get their own version of it and own changes in that, then they'll have to get a certified standing order. So, in this, it's very important to understand that there are separate units. It can be treated as one establishment wherein there is a strong functional integrity and unity of the management, and workers are generally treated as single pool. So, maybe two different units, but the entire management is managed by the same plant manager or the CEO. Then, in that case, both of these will be considered as one, and it might be 201 and 250 in the other establishment, and together they'll have to have a standing order in this case. Then we have the fixed term employment. So this is one of the new concepts which was covered for gratuity and all of these other parts. So what do you mean by fixed term employment? Anything or any person that is hired or hired through a contractor or directly by a written time bound contract with same wages and benefits that a normal employee would get. So it's very important to understand then what would be considered as retrenchment here. So retrenchment is basically whenever a person is removed by the factory owner or the industrial establishment owner. So in that case, they will be considered as retrenchment, and accordingly, retrenchment compensation as well as reskilling fund will have to be given for them. Now, to understand if it's a fixed term contract, and it's very clearly mentioned that it is maybe for a year from January till December 2025, the 2026. Okay, so January to December 2026, it is a fixed term contract, and by 26, it will be December, it will be over. It is very clear. So that is not retrenchment. However, if it is January 2025 till December 2027, and the person, maybe there might be some shortage of work or closing of the establishment, or for whatever reason it might be, and they do not need any more employees. And so maybe by June 2027, that person is removed. So in this particular scenario, it would happen, it would be considered as a retrenchment. But if by any chance, on cases of non-renewal of the contract, it will not be considered as retrenchment. So then what do we consider as continuous service? Because continuous service is also one of the leading factors on understanding the retrenchment compensation. So any establishment which is working 6 days a week, so 240 days is ideally considered to be as 1 year, like with the similar calculations for gratuity also. So 240 days equates to 1 year. This is the continuous service calculation, whereas 190 days in continuous processes, and for establishments having lesser days. Then we have, this is like in the preceding 12 months, these days might be considered. So why does it matter? First of all, the layoff part is there, it's directly linked to it, and continuous service, the retrenchment benefits. Then we also have a gratuity entitlements and as per the Social Security Code. Then we'll just move on ahead because I've already given the example also in this part. So then we have the trade unions and registration. So what carries over, what still remains? So the shift here is that there's a new chapter now that's included in trade union chapter under the IR code. So the minimum membership required for registration is the same. It has to be registered with the registrar of trade unions. Then it becomes a corporate body with common seal. All of these parts remain the same. Basic rights, obligation, everything remains the same. In fact, one of the best part about these codes are that any trade union that were earlier, that were already in existence, they will still continue to be in existence. There's no change for those trade unions. They were existing before, they are still existing now, and they will continue to be on the same. There is no registration, no second registration needed, no changes in that part. Now, this is one of the most important facts. So, this is with regards to the negotiating unions or the negotiating council. So, what do you mean by them? So earlier there was no concept as such. Now there is a very interesting concept wherein a single union, wherever there's a single union, or maybe there might be more also, but there's one single union that has 51% majority of the workers. So in that case, that specific union will be a negotiating union. So here's a poll question. I might have already like, given you an idea also on it. So the 300 worker threshold applies to whom? Is it a company-wide headcount, each industrial establishment, only factories, only if unions exist? So I hope this is clear to you, and let's get an idea if it is or not. Okay, so we just move on back to the negotiating union part. Meanwhile, I can get the polls also done. So yeah, the single union part. So the single negotiating union, 51%. Very clear, 51% is the membership that they require from the entire establishment number of workers. Now, if there is no such trade union that has 51% membership, maybe there are four trade unions, each of them might have, one might have 40%, one might have 20, and the other might have 30. So in this case, they all of these trade unions, the representative from them will come together and form a negotiating council. So this negotiating council, together with the members of all the three unions, will then have a right to do the collective bargaining, negotiation, and everything with the employer. So similarly, either it will be a negotiating union or a negotiating council. Either of them will have the only rights to do collective bargaining. So this is a very important and major change this code came up with. Then we have what they negotiate. So the wage hours, the wages, working hours, leave, discipline, retrenchment, closure, grievance system, everything they can only these negotiating council and negotiating unions have a right. The remaining it might be like the remaining trade union members, they won't have a right to negotiate and go directly. They'll have to go to the negotiating union or the negotiating council, and accordingly these unions and council will be able to put forth their part. Then numerical example that I'd given, none, because this is on a proportionate basis. So on a proportionate basis, so the one which had 40% membership will get maybe 4 seats or 5 seats. Then the second trade union which had 30% membership might get 3 seats, and then we have the third council. So the third council will usually have 2 seats. So out of the 10, there'll be a maximum capping of 10 members in the negotiating council. And accordingly, depending on the proportion and the percentage of workers in each of these councils, sorry, in these unions, they will have their seats in the councils. So let's move on to the standing orders. As I've already mentioned, standing order is one of the most important parts here. Earlier, any single establishment or any single unit having 100 or more would have to fall under the standing orders part, and they would have to get a standing orders, first of all, model standing orders, and accordingly, then it would be changing on to the specific standing orders, and which will be certified later on. Now, the threshold has increased from 100 to 300 or more workers. So many units that are certified already as per the earlier ones of the earlier limit of 100 will still remain in force, and they will not be changed. This is a very clear thing to understand. They will still remain in force because of the saving clause that we've already mentioned. They will still remain in force because they are not inconsistent with the IR code. So, what does the standing order specifically consider? The classification of workers, hours and shifts, leave and holidays, misconduct definition, suspension, dismissal procedure, termination and notice, and grievance redressal. So the flow of it, or how to get your the certification of a standing order. So in general, once the state rules and the central rules are released, you'll get a model standing order for them. So once you get the model standing order, you'll at least have an idea on what the standard lease, standard everything which needs to be covered in that. Accordingly, meanwhile, you start drafting your own standing orders. So the procedure is moreover the same, wherein you draft your own standing orders and cover all the mandatory matters that needs to be there. Then you share it with the union or the workers. And accordingly, the union, which is at this point will be the negotiating union, and the negotiating council will go through it. If there is any suggestion or objection, they will be addressed within the stipulated time. And once that is done, there will be a hearing to the certifying officer. So once the certifying officer hears both the sides, considers the submission, and once it is finalized and it's okay with both the negotiating union or the council and the employer, the final version is released, and the final version is then given, and this final standing orders will be displayed and the will be circulated between the workers as well as displayed on a notice board. So next we have one of the new concepts released by the Industrial Relations Code, the Grievance Redressal Committee. This is the first internal stop. So let me be clear here. Earlier, there was no such thing. It would just go to an HR, or some of the employees or the workers might just go to the labor court directly. So to stop all of that, there is a grievance redressal committee now. So there's one more changes that I need to highlight here, that there will no longer be a labor court. So the labor courts are now going to be transformed in only and only into an industrial tribunal. So there was earlier labor courts, industrial tribunals, and national industrial tribunal. Now it has changed into industrial tribunal and national industrial tribunal only, wherein the national tribunal deals with the matters of any industry or any specific part which relates to one state or more than one state, but on a very big or very important matters only. Whereas all the other cases will go to the industrial tribunal. However, instead of the labor court, now the employers have a better option wherein they can just go to the grievance redressal committee. So every single establishment having 20 or more workers will have to will have to form a grievance redressal committee. So what is it? As the name suggests, it is for the individual worker grievance itself. So the composition, it consists of the representatives from the employer side as well as the workers side, as well as the maximum membership of it is 10 people. So in that, depending on how the proportionate number of women in the company, the advocate number will be provided, and proportionately women representative will also be a part of this composition. So there is no gender bias here specifically. And how it works, so in normal, how a basic in posh complaints or any other complaint it works, that whoever whichever worker has a grievance will write give it in writing. So it's mandatory to give it in writing, okay? And once it is given, the Grievance Redressal Committee, the GRC, will hear both the sides within the stipulated timeline. Ideally, the timeline as of now is 30 days, within which they have to take the hearings, provide a written decision, and communicate to the worker. And if try to resolve it as soon as possible, and if it is not resolved, then it goes up to the conciliation, and subsequently it goes to the tribunal. So conciliation will be the next course of action, where a conciliator will be appointed, and accordingly both the parties will hear what's happening, and one they'll try to provide a redressal on the same. So once conciliation in the dispute gets resolved through conciliation, well and good. If it does not, and if either of the parties still have some grievance or something to be redressed on, then it will go to the industrial dispute resolution. Judges unfair shift change. So the GRC will first check. So they'll check the shift policy, they'll check the submissions given by the worker, and they'll provide a time for the hearing. So as it is Audi Altrum Partum, so both the sides will be heard. And the rules of natural justice will prevail, and they will either correct the issue and the records the reasons why it was stated. And if the worker still has some dispute with the same, they have the right to go to conciliation or the alternate dispute resolution mechanism. Let's move on to the other part now, the industrial resolution machinery and OV. So, what is an industrial dispute? So, industrial disputes mainly consists of disputes relating to employment, non-employment, terms of the employment, and labor conditions between the employer and the worker or the unions. So, as I've clearly mentioned, now the entire concept of labor code is not there. Now it will just be industrial tribunal and national industrial tribunal. So the conciliation officer, they'll be the first step after the grievance redressal committee. They'll be the first step as an alternative dispute resolution part, wherein they will try to promote settlement as much as possible through meetings, discussion, and mediation. They will record the outcome and provide a memo or a failure report in case it fails. Then it will go on to the industrial tribunal, wherein they will adjudicate disputes, including dismissals, retrenchment, interpretation, and standing orders, and settlements will be provided. Once an award is given by the industrial tribunal, it is binding on both the parties. So this is very important to note. Conciliation officer, when they provide a report or a conciliation between them, that is not technically binding. They can definitely go ahead and go to the industrial tribunal. But if it is an award passed by the industrial tribunals, it is binding for both of them. So, similarly, for National Industrial Tribunal, it is of any matter having national importance affecting establishment in multiple states. So, example, wage dispute goes to conciliation, fails. Then both the parties are not agreeing, a failure report is filed, the matter is then referred to the Industrial Tribunal. So, Industrial Tribunal passes award and revises the wage scales, which is binding now on both the employer and all workers in that category. So we'll move on to the next one. What is strikes and lockouts? The rules in brief. So the definition of that did not change. It is still the same. That strike is basically a collective stoppage of work by workers or a concerted refusal to work. Whereas a lockout is from the employer's side when the employer temporarily closes the workplace or suspends work or refuses to employ some workers. Maybe because of maybe because of uh, the problems with relating to there might be shortage of work or else shortage of supply. In that case, they could either have a complete work lockout or they can lay off certain employees. So layoff is still a different part here. Lockout and strike are basically complete stoppage of work. So in case of either of them to be legally valid, a 14 days notice is mandatory. So a 14 days notice in advance has to be given. Accordingly, a cooling period is given. So you cannot, the cooling period is basically in that 14 days, you cannot directly have a strike or a lockout. If you do that, it is an illegal strike and a lockout. The validity of this is typically either 60 days or 90 days, that will be given in the rules. So from the day, for example, if it is 1st of January that I'm mentioning, I've given a 14 days notice. 1st of January is the strike or the lockout period. So 60 days from that. So maybe till March or March end is the maximum timeline I will have to have the strike or the lockout. But beyond that, then I cannot have it. Then we have the prohibited periods. So during these specific periods, there cannot be any strike or lockouts, like such as the conciliation time. So if a matter is gone to the conciliation board or else the tribunals, or there is an award or settlement already passed. So during that time, you cannot have it. You cannot at any point of like in these times have a strike or a notice. It will be illegal and it will be considered going against the law and the codes. So there could be a legal action taken against you. In case of a strike, there could be a loss of wage and a disciplinary action and penalties in case of employers doing a lockout in this thing. So we'll move on to what is layoff, retrenchment, and closure. So layoff. Specifically, workers on muster roll not given work for listed reason, power shortage, raw materials, etc. that I mentioned. So they can typically ask 50%, 50% of their employees or maybe a certain number not to come during that time. So if it is an employee who's already on a continuous service at least in the past 12 months and they've completed 1 year as per the continuous service definition, then they will have to be typically given basic 50% and DA per day on the duration of the layoff. So, for example, they've been laid off for a week, and maybe that their daily wage would have been 500. So, in that case, the 50% of the basic and DA will be 250. So, 250 for those 7 days will have to be given to that employee or the worker specifically. It will be have to given to that worker. Then we have the retrenchment part. So, as I mentioned on the continuous service part, and considering continuous service of 1 year, so any person who's terminated for any reason other than misconduct, superannuation, fixed term employment expiry, and voluntary resignation For any other things except these, they will be considered as retrenchment, and the compensation will be provided to them, which is 15 days wages per completed year of service. Whereas closure is the permanent shutdown of the whole or part of the undertaking. So it could be that the entire unit has been closed down, or else it will just be maybe half of that unit is closed down. So more than half of the workers will be retrenched on this part. So the compensation is the same as retrenchment, wherein 15 days wages will be provided for every completed service, every year of completed service. So now, just an example for retrenchment calculation. Workers with 7 years and 8 months of service. So as per the continuous service definition, 8 months will be considered as 1 year. So their calculation will be on 8 years. So the last drawn salary was 30,000 per month. In this case, it will now be considered as 15 days salary, and 15 days salary in this thing is 15,000. So 15,000 divided by 26 into 8. So 8 is the number of years that he's worked. 26 is the number of days in a month, and according to the calculations provided, which is 1,38,462, which will be his calculation of retrenchment specifically. And the permission regime. So above 300 workers notified in industries, factories, mines, plantation require prior government permission for retrenchment and closure. So for any unit or something which has lower than 300 can directly do it, whereas for any unit having more than 300 workers, they will have to notify the appropriate government before doing that. So let's move on to one of the new concepts again, the reskilling fund, which is a very new obligation now. So we already have a retrenchment compensation that's given in case of retrenchment as well as closure. Now, reskilling fund. Now, reskilling fund is basically to help an employee who's been retrenched specifically to get back on his feet and to get back to a new employment. So basically, re-employment help you. Okay, so one of the polls here. So continuous service is deemed when a worker completes how many days. So I've already clarified this thing, but I hope you guys have understand that. And let's just stick here. So it's supposed to be either 365 days, is considered 180 days, 240 days, or 190 in continuous process and industries, or only paid days are considered. So I just hope you guys had an understanding on this concept of continuous service. Okay, so let's get back to the reskilling fund part. Now, what is the reskilling fund and who pays it? First of all, it's paid by the employer. So, in case of a retrenchment or a closure, the employee, the worker specifically, sorry, the worker will get the retrenchment compensation as well as a 15 days salary, the last drawn salary that he had. 15 days salary will be given to a reskilling fund, which indirectly will be coming back to him. Now, as is clearly mentioned, the employer contribution mandate. So, specific threshold now mandated to contribute a specified amount for each retrenched worker, and this is a critical compliance requirement. Then we have oversight and administration. So, the fund is administered and overseen by designated authority who will be designated as per this code itself to provide transparency and effective utilization of the resources, guided by specific details notified by appropriate government. Now, this reskilling fund also has a financing skill development. So the primary purpose is basically to provide them a skill development initiative and the time to adapt to new industry demands and gain relevant re-employment opportunities. It also empowers workers for future employment. So it ultimately leads to a pathway for retrenched workers to successfully transition from their old roles and the new roles, and in between the timeline, by the time they get a new opportunity, they do not have to keep on worrying on how their family would go around, how what they would do, or what makeshift job or makeshift roles they'll have to take. So this is a very good concept that's been released for them. Now let's move on to the other part, which is the unfair labor practices. So unfair labor practices can happen on both sides of the line. One is the employer part, so interfering with union formation and administration. So this is an employer's unfair labor practice. So they, whenever there's a union formation or administration, they unwantedly intervene in that. They try to influence them, victimize the union activity, refusing bona fide collective bargaining, using goons or strike breakers in prohibited ways. So as you already know, getting goons and all in case of a strike and all is absolutely prohibited, and it could also comment as it also be committed as a criminal offense. Then discriminating to discourage or discriminating between the union members, so that there is a discrimination among them and one union is more preferred, that is also highly unacceptable part and considered as an unfair labor practice. Then from the union or the workers part, violence, geraos, wrongful confinement, preventing willing workers from working. So in case if some of them want to go for a strike and the others do not want to, forcing the ones who want to go on a strike, stopping them from coming there, then to go slow or walk to rule tactics. So here, in case if a production or something is supposed to happen in a month, or maybe some product is supposed to get done in a week, they will on purpose stretch it out and not work, go slow and get it up to 15 days or 1 month until and unless their demands are fulfilled. Then we have damage to the property. So this is one of the major things. It is a completely unfair labor practice, unacceptable, unethical, as well as it can even go up to the criminal side and also have consequences on that to property damage. Then we have the coercive activities during disputes. So the consequences ideally is that it attracts desist, penalties, damage credibility on both the sides, and can also impact the union recognition as well as their bargaining status here. Then let's move on ahead and get an overall gist on what the employer or the HR needs to do in 2025 to 26, and understand the transition year. First of all, to identify the appropriate government, whether your establishment falls under the governance of the central government or the state government. Okay, so this is one more poll question here. Do you know which is the first stage of dispute resolution under the IR code? I am pretty sure I already explained couple of times on that and highlighted this part now. So let's hope and let's get an understanding if you've understood now which of these parts are supposed to be there. Okay, so back to the employer-employee checklist. So first is identifying the appropriate government. Then we have the map establishment and headcount. So you need to first understand your establishment and unit-wise how it's going to go on. Like it's supposed to be if it is 1,000 employees, 1,000 workers that you have, and that is come like spanning across different units. So accordingly, each unit wise, you'll have to understand if the threshold crosses 300 or not. If it crosses 300, then definitely you'll have to go on with the standing orders part. Then understanding the union status. So you have to make sure and make a point to let the unions in your establishment understand that they need to now create a negotiating union or a negotiating council. So if there's a single union which is very strong enough, having 50%, 51% and more membership, then definitely they will be the only one having the negotiating union rights to have collective bargaining. But if they do not, then they will have the all of these trade unions will have to come together and form a council, and this thing you will have to communicate with your workers and their trade unions and get this done. Then you have to review your standing orders. So if you already have it already in your establishment or your factory, then definitely it's a good thing. It will still stay the same. In case if you do not have, you will have to start preparing as per the model one, and then the same procedure goes on. Then one more thing, you have to start a new grievance redressal committee. You have to form that and make sure it's functioning properly, constituted, and ensure proper representation is provided to all of them. Then you have to prepare standard procedures. So create a clear template on how the strike or the lockout is supposed to happen. The notices are given, then conciliation is provided, layoff retrenchment is provided. Also, make sure the reskilling fund payments are given on time. So, whenever there's a retrenchment happening, please kindly ensure retrenchment compensation is given, as well as reskilling fund amounts are given to them. And the main part, the train line managers. So conduct training on disciplinary procedures, inquiry procedures, unfair labor practices, as well as giving them an understanding on the new labor code and the new things that are supposed to be given for them, which is the union status now, the GRC, and the reskilling fund part. So this is all from my side now. And now the key takeaways that I'll just give you an overview on, which is basically the AR code pulls together unions, standing orders, disputes into a single part. Then the critical part of 300 and more workers, more structured regime, and the saving part. So the saving clauses, wherein who are already in existence, the trading trade unions, the standing orders, the awards, conciliations, which are already existing, they still continue to be the same. Whereas all of these disputes that are still pending before the courts are going to be converted into they'll still be the same. However, the section and all which they were considering in the earlier acts will now have a similar effect, and whichever is a similar section in this code now, it will be converted into those sections. So for example, just an example, if there was 118 section which was used under industrial dispute, and in that part there was a case going on, so that will now be converted into part 2, maybe part 2 or part B, and section 47 of the IR code. So basically the section and the terminologies will change, except that all the cases and everything remains the same. So this is all from my part. I hope you all had a clear understanding of the industrial relations code. In case you have any more queries on that, please feel free to drop below in the questions and write to us. Now handing it over to you, Pratik, to give an in-depth understanding of the OSH code.
Thank you, and wonderful presentation, Sadaf, and the whole team has done a wonderful job, and I'm sure that the all participants have. Uh, I hope they are not overwhelmed for overall information. So, guys, I'm going to take exactly 1 hour. So I hope you're going to be staying for me with 1 hour because OSH is very, very important. That's the reason we kept it at the last. And while you know, the IR code is more about relationships, union, dispute, discipline, and all that's a relationship between employer, employee, and union. The OSH code is more about life and limb, whether people go home safely, healthy, and with dignity. That's what OSH code is. So I hope there's a permission for me. There are around 450 plus participants, and I'll exactly take an hour, including some question in it. So stay with me till 2 p.m. And we have a lot of things to cover. Yeah. So why this matters is as I told it is more about home safe and healthy and with dignity. It's important that the HR plant heads, admin, you have EHS, your contractors, and frankly for the CFO also, because one serious safety incident can just wipe out the years of profit and goodwill, and that's very important. Becomes your headline item for the news item as well. So let's look at how the OSH code changes the landscape, which are the acts which are merged in all. Can we have the next slide, please? So here on the slide, you can see all acts which are like factories, mines, plantation, dock workers, mode transport, building other construction workers. The welfare part of it is already I had covered in the Code on Social Security, but there's the act part which is there, that Interstate Migrant Workers Act, BT and SIGA, plus the older health and safety provisions which were scattered around. Now, each of these had its own inspector, forms, registers, and compliance to be done. And especially you're in factory or a unit, now everything is under one umbrella and OSH code, which is there. And there are specific chapters for specialized sectors, like say your mines or dock workers or motor transport or plantation, BDCGA. So they are like a special chapters for that. Otherwise, everything is under one. So important is, as Sadaf has also clarified, that all the codes which are there and all the acts which are subsumed now, the savings clause will still continue, which means that all licenses, registrations, approvals, the way you used to take factory license, the Contract Labor Act, registration, amendments, and licenses will continue till the time they formally it migrates it to the OSH regime in this particular case, or any other code regime which is there. So it's going to be a standard thing, the savings part. Yeah. So let's look at the overall objective of the design. It's like a whole it's single framework, right? So whom it is applicable to. That's very important. Uh, it is all about one. The whole objective is just one single framework, one establishment registration direction, uh, you can say that, see, if you are a factory, you need to do a factory registration, then you need to do interstate migrant worker registration, then you may have to do contract labor registration and amendment, all those things. Here, you'll be just having one kind of a registration, and then you need to maintain certain one side of records if you're a principal employer, and then upload those compliances to the authorities whenever asked for. So it's going to be more of risk-based inspections, which means whenever you upload your data and whenever asked from the labor department under the OSH code or any other codes as such, if they find any anomalies or they find some inconsistency, then they will do a risk-based assessment and inspection. They will call upon the inspector. They'll give you a notice also that, and they'll not be coming, like as a surprise visit. So that's the whole objective and design of OSH codes, and for that matter, all the codes actually. So that's very important. And some of the sector integration of, it's across all the industries. The sectors are integrated, which I just mentioned about ports, mines, and all those things. This is very important. Most important part, even this OSH code is about hours of work, which is same as 48 hours, 8 hours a day and 48 hours a week. But important point is that the women working at night, which was never there, like in factory that section 66, it was not there. Now it is there as a formal thing. So this is what the objective design is as for the code. Can you just go to the next slide? Yeah. So which establishment workers? So I already clarified here. Uh, the establishment means any place where industries, it is a standard establishment, uh, you can say definition. And mind you, this OSH code does not cover Shop and Restriction Act. It's a state specific thing and it's out of this whole. What it covers is only these acts which are mentioned down, whether factories, construction, and all those things. Whether establishment, okay, if you have a shop and restriction and you are establishment covered under Contract Labor Act, then that only the Contract Labor Act part would be covered under OSH. Rest of it will be under Shop and Restriction Act. So that is what you need to understand. Even if you have contract labor and you're also hiring some interstate migrant workers, so these two parts will be coming under OSH code, rest it will be Shop and Inspection Act. So this just I wanted to clarify the coverage and what does that mean, in fact, on that particular front. Can you go to the next slide, please? Yeah, I think appropriate government SADAF has already covered broadly central covers, and it was under Industry Dispute Act earlier, but now it broadly covers this railway, ports, mines, oil, and major central PSUs, where more than 50% are held by the PSUs. And other notified bodies, and state mostly covers the private companies and private factories and warehouses, IT parks, and so on and so on. See, it does matter because when the rules and notification and the portal, it will be coming out. Um, if at all a central labor or central authority comes to you and you are covered in the state, you should be able to tell them that no, we do not come under central, we just come under state. That's very important. So mapping is very, very important. Which OSA chapter is mapped to what routes, That's what it is important. Can you next slide, please? So we were talking about single OSH registration, as I mentioned, per establishment, single OSH, which will have licenses that can cover multiple functions like factory operations, contract labor, interstate migrant workers, everything. All this sitting on a digital platform with returns and inspection all linked. So earlier you had different authorities for different things. It will be just one single OSH registration. So world of scattered licenses and everything into one just integrated compliance identity per unit. Similarly, for contractor also, the contractor had one, he had to have every, say, 30 locations across India, part central, part state. he need to take 30 licenses if the threshold limit, for example, goes more than that. He just have to take now one registration which has 30 names or principal employer or details under that. And whenever the principal employer asks that whether you have a license in place, he will show the one single license with all the 30 names and his name is there or not. So that's for the whole concept and example what they want. The government will clarify next 3 to 4 months how it's going to do. So this is what I wanted to explain this about registration. Here I've given more example here. As a principal employer, you get covering a factory contract labor, interstate migrant worker as one particular unit, and contractor may just get one license covering all the clients and all. So I give the example of facility management as well. So this is what it is. Take a example like you have 250 employees on your rural and 150 contract workers, right? So under old regime, you knew you need to take factory license, CLR registration, ISMW, all that, even building and the construction, if it is not part of factory, it's all separate. So under this is all consolidated. That's what it is. So this is important. Uh, a large security and housekeeping contractor doesn't now live in disconnected silos. The department can see their full scale on one screen. And if you're a principal employer, you can also check whether he is a good contractor or not, and whether he's having a license of his previous contracts and all. The way we cover in our audits as well. So that's what I wanted to just check, and I share you that information on that. Let's go to the next slide, please. So what happens to the existing license? We already specified here. It'll still remain. The old license, if it is issued and say the license value up to 26 or 27, it will continue until the new rules are specified. It will continue. The new registration, the portal will align, the updates will happen in the next 3 to 6 months. And then you may have to do the new registration post, say, 26 or post, say, 27, depending upon the validity of license, which is there. So they are saved until it is migrated. That's as simple as that. Just wanted to share that particular information on this. Can you go to next slide? So when we talk about factories, it is clearly it's like back to the basics. You need to ensure that you have a clean, ventilated, well-lit workspace, safe plant machinery with gas and products. That all doesn't change. It is there. It has to happen. You need to ensure that you have PPE, you have first aid, you have ambulance wherever required. Drinking water, toilets, washing space. So all those things which is required under Factories Act and all, it just still remain the same. Larger pieces remain the same. Even the creche and restrooms and welfare officers, based on the headcount which was there under Factories Act, will still be there. So, but the basics. So first thing, inspector and employee, or frankly, any client will notice is that whether the canteen belonged to 1985 types and now it is a big five-star reception. It depends upon that, how well you manage it, So that's where it is. So you need to ensure that you you continue with whatever is there in factory, that unless they specify rules as far as OSH rules are concerned or schemes are concerned, they want to change certain things, but everything remains same. So just want to just share that information on that. I'll just take the quick questions. I hope I'm not rushing through. Yeah, so the one other question was that effective date has to be 21st November. I'll tell you, except PF Act, which is not repealed. Whereas all the acts are subsumed and repealed, and you need to ensure that there is no other notification coming. The act is applicable. Rules and schemes, as it was going on, the threshold limits as it was going on, all that will continue. But you need to just ensure that you do a whole wage restructuring, which we can also help you. Salary restructuring as per the new labor code. That's it. Simple. Okay. Next slide. So here, working hours, overtime, it was there. There are some states will be there is 8 hours. There are some states 9 hours to 12 hours as well. You'll be surprised. But now it's all uniform here. You'll have 8 hours, 48-hour week, and rest drills which are there, and need to ensure there are certain times where you have a peak hours about spread over hours of 11 to 12 hours. But you need to ensure that you don't in a serious accident, your timesheets and access logs should be important, and it all has to be logged. it will just speak more than my PowerPoint presentation here. So you need to ensure that you maintain all the compliances importantly. You need to ensure that if the worker is working more than 8 hours, and that overtime is given the double the rate of wages. In some states, it was 1.5 times. There are some states it was 2 times, but now it's standard across India. It's going to be 2 times itself. That's very important. Next slide. This is one of the important. If you remember under Section 66 of Factories Act, I mean we never had the provisions. We had of the some of the states did provide about women in night shift. They can be allowed to work, provided you have a company arrange transport and safety and everything. But now it's become standard under OSH code, even factories or whichever workplace is there. As an establishment, as an employer, under OSH, it can be any establishment, and in night shift, if the woman is working, it can be. It's a big change actually. So, but you need to ensure that it's the women gives a consent that she will be ready to work. That's very important. An employer has to ensure that safety and transport measures is taken. And one of the most important, which was not there in early shop illustration and all, but now they've made it part of OSH code. It's very critical that that POSH and other safeguards are there or not. So that's the compliance of POSH becomes also very, very important. So outside the labor code, but the linkage of POSH is there. So you need to ensure that if the contractor is there, they have their own POSH and all, and that is also covered while you do an audit and compliance check of the contractors as well. So that's very important. So it was very uneven earlier, now it is. So typically, if you're rostering a woman, especially between 9 p.m. and 6 a.m. That's called a night shift. So then you need to be answering all those questions. Are you giving comfortable transport, lighting, access, ICC? And this record you need to maintain so that if at all there is a dispute or if there is an inspector who checks all that, in mind you, they will be checking the soft copies of all the data information you have with them, and they will be then doing risk-based inspection just in case there is an anomaly. So you need to ensure that while you deploy this women night shift working and all, you ensure that while you may say that, yeah, we are providing safety, company are in transport and all, or security and all, you need to have all evidences in place. That's very important. Can we the next slide? Here, I've just shared with you what are the 5 days work and 6 days work. It's very, very important that uh, so all depends upon and they're generally 6 days working is in common in factories and service sectors and all, and 5 days in all corporates and all. So now you cannot say that, okay, 48 hours a week is there, 6 days is there, so 48 hours a week is there. So I will work for 48 hours. And in corporates, you say I'll perform 4 days a week and I'll give for, and then the employees have to, work 12 hours per day. That cannot happen. It is 8 hours or 9 hours with a rest of interval and 48 hours is the maximum. So you need to also consider both. So even if you're keeping 5 days a week working, so it will be 40 hours. 4 days a week working, so it will be considered as 36 hours, including the rest of interval. That's very important. It cannot be 12 hours per day for 48 hours. So that's what I just wanted to share. This very, very critical info because we come across many of the companies, including multinational companies, who want to set 4 days or 5 days working, and they want to extend the number of hours per day more, and which is not acceptable or applicable at all. Just wanted to share this. That's very important. Yeah. Next slide. So contract labor, we know what is carry forward, and I've given this example here that one of the principal employer, you need to ensure that earlier also it was a joint responsibility. The same thing continues here, where the contract first the contractor has to ensure all the wages is given, all social security benefit is given, all the compliance has been done by the contractor to the contract worker. And if he does not do, principal employer cannot be absolved of the non-compliance of the contractor. Principal employer then becomes the uh, you know uh, responsible party enough to ensure the compliance of the contractor, wages, of course, social security code, everything under all the labor codes, and that's very, very critical and important information. If you fail as a principal employer, while you can always recover from the contractor, but first aspect is that you will be penalized and you should be paying to the wages or any of the things which is not met by the contractor to the contract worker. And then you may be able to recover from his invoices and bills and all accordingly. You cannot say that I have paid to the contractor and he's not done, it's not my job. No, it's because he said he's working in your premises. It's very well, it's a joint responsibility as well. That's what's there in section 10. It was covered. It's already covered here as well. Next slide. Okay, so I've given some example here. Can you just go back, please? Yeah. I've given some example here that how this will work, right? And we know this. Say if you have a total of 180 employees as contractors, so only security and housekeeping, assuming that the headcount limit or threshold limit is 50, which is most of the states except the central is now 20, but that also may change now with the new rules and all. So assuming this particular scenario, 70 and 90, only those two contractors need to take license, which means in their own license, they'll be mentioning this, your name as a company name, because you have more than 50 employees. Whereas gardening, it does not have to take license. He'll not be having it all because he's having less than 50. Here in my example is 20. So even in your registration, you will not be mentioning gardening contractor at all. That's what the registration will mean. Anything which is below that will not be eligible for license as well. Yeah. And next slide. I already clarified the wage responsibility jointly, which is if the contractor fails to pay, inspector directs the principal to pay. That's very, very critical. It was there earlier. Now it is much more established here because earlier the fines and penalties were not so much. Here right now the fines, penalties, and prosecution is very, very high. It may go up to lakhs of rupees if you do not comply, or if the contractor does not comply and the sword is on your head to ensure that the contract complies. Otherwise, not only you'll be penalized lakhs of rupees, starting from minimum 1 lakh, but also you need to ensure that whatever anomalies are done by contractor, you need to pay up that as well. So it's penalty and fine plus whatever, if at all there are monetary issues like wages not paid or bonus not paid, that also you need to pay. It will not be compounded for all those things. Yeah. So I've given an example of the canteen contractor not done. So that is very important. So now, ending the contractor will not absorb your risk. For example, many of the contractors, if they are not compliant, you may just terminate them and a non-compliant contractor, right? That's what when we do audits and everything with your organizations and so many uh, it does not erase your past dues of the contractor. That's very critical. You need to ensure that you have whole repository of all the compliances, be PF, ESI, all labor, all things at least up to 5 years from the contractor, which is very, very important. Even post termination, because the authorities will ask post termination of, and they'll demand, and it can go up to 5 years, up to 3 years. Because, for example, many wages not paid 2 years back. Okay, after the code is issued and say in 2027 minimum is not paid, the contractor, the authority can ask you to resolve this mini wages to be paid to the so-called employee as well. So you're going to, as a principal employee, you're going to carry a huge risk. Need to ensure that the contractor is really clearly compliant. Now, this is especially now, with the wage code is already issued. I mean, all labor codes are already issued. Most important part is the ESIC. PF is still not repealed. ES is really repealed. A lot of questions which I had in so many forums, and we have already shared also. ESIC is applicable as on 21st September. So for a contractor, you need to ensure at least from 21st November, beg my pardon, from 1st December onwards, all employees are covered, and then you do arrears on wages from 21st November to 30th November. Ensure that the new wages is the benchmark for ESSE contribution, which means typically gross wages were around 21,000 and above was not covered under ESSE. Now, if you have say even gross around 40,000, like a total remuneration of 40,000, just because the 50% of the core wages is under 21,000, which is 20,000 in my example, he would be covered under ESSE. So all the employees who were between 21,000 and 40,000 typically would all be coverable from 21st November 2025. mind you. And this is very important for you as a principal employer for your own employees, but more important for your contractors also. And you need to ensure the contractors comply. You may have to ensure you increase their remuneration, or you need to increase their billings. All those, especially the contractors who have fixed billing with the client, you need to go and negotiate with the client, because this is the compliance which you need to do. It's a big jump, actually. Between 20 to 40, all those will be covered under ESSA. Just wanted to share this very, very critical and important information to everyone here. Yeah, can you go to the next slide? So let's talk. Uh, this is a very, very important information on interstate migrant workers here. Earlier, if you know, interstate migrant workers are only applicable. For example, if a contractor is bringing, in my example here, a contractor bringing say 200 workers from Odisha to Maharashtra, so he goes to the Odisha, he collects some 150, 200 people, gets them to Maharashtra, pays them some allowance, travel allowance and all, and recruits in Maharashtra to do any other work, right? This is a classic ISMW that is really covered, and it is coverable under this code as well. However, imagine a situation which is very clear, and in fact, some of the workers who may be considered under 18,000, and they're coming, say, for example, from Bihar, or say any other state, and they go on their own to factory in Delhi. This will typically happen in NCR. A person working in, staying in Delhi goes to Gurgaon, or goes to Faridabad, or goes to, Noida for work. It will be considered, even if he's gone on his own, it will be now considered under interstate migrant worker. And this is a big, big change, very big change. So you need to maintain roster of all those, including the Aadhaar card, where he's staying, his domicile. His domicile is other than the state he's working. If you are more than five employees, which is like currently the threshold limit of ISMW, I believe the same will continue until the notification comes. All such five employees who are, sorry, five workers who are there with the threshold limit of 18,000, all would be covered under this code, which is very, very critical as far as ISMW is concerned. I'll repeat again. There may be a worker from Gujarat, from UP, from AP and XYZ, staying in Mumbai with on rentals and all. Fine. They come to you, I want a job and I want to be, getting it. You will employ 5 to 7 people, such and they'll give the job and appointment letter in Mumbai itself in your office. Because these people are coming from other state, they will be now be covered under interstate migrant worker, which was not the earlier case at all. So this is where it is. See, this is done because you know what, earlier, though Act was very much sacrosanct on that, but most of the people to really have a middle way out, they used to call the people from say other states and issue upon letter or letter from the home state and say interstate migrant not work applicable because they all are from local only and have sourced them, though their domicile is from, say, Odisha or Bihar, etc. and all. So this to just ensure that the worker is really taken care of. This is a new change and expanded definition under interstate migrant workers for under OSH code, which you need to really, really ensure that you take a note of this very close. There are some questions on PF. PF says, I'm just repeating again, PF stays as it is. The wages, the definition of wages for PF is as it is, as was the new earlier definition, based on Supreme Court judgment, ordinary, necessary, uniformly and all. But ESIC changes, gratuity changes, all other things change, as per new wage code or new labor codes. That's what I just want to reiterate again and again. However, you should ensure that you have at least 50% parlance in a way that when the PF rules come in for a next 2, 3 months, 6 months, you compliant enough. That's what it is. All right. So key benefits for the interested migrant, which is there earlier as well. These are the benefits which is there, where um, technically speaking, it has to be parity with the local workers doing the same work, and because they should be also getting displacement allowed, even if you are recruiting from the home state, and even if you're recruiting and the person is coming from on his own, even if he's from the other state, you still need to give them displacement allowance and journey allowance, because they may go to their leaves. They may typically they go for leaves, and when required, this journey allowance has to be given to those particular contractual employees, or even the work, whoever the workers are there, and things. You need to ensure that these set of information is really well maintained, especially Aadhaar card and all the information which they have, like a know your employee all documentation. And HR should ensure that whether it is their permanent employees or contractual employees, are they covering under interstate migrant or not? And if they are coming from other states, they need to take a declaration. They need to ensure that they are covered under ISMW, and they may take the necessary registration accordingly. Yeah. Next slide, please. So this is a kind of a thing that how the data capture should actually happen. It should be made a part of a joining form. It's just a small example I've given this, where what is the permanent home state, when he had moved, what is the wage level he had, what is the contractor name, date of work, arrival in work state. So this is very important, which should be important to note all those information. That's what it is. Let me go to part two of my series. But before that, I'll just take a break here of 30 seconds and look at some of the questions. If you understood well about it, and I'll ask my team to see as much as questions you can answer them. There are some questions which is to avoid double the wages, non-ensure. Please ensure that you just type in a way that we will be able to answer the questions around it. Chitra is asking that 50% of CTC. Please understand that, see, you need to go through my presentation of wage code. It's not CTC. It is called total remuneration. That's very important. So it is not 50% of CTC. It is 50% total remuneration. How the total remuneration done? Please go through my presentation on the wage code, and you'll understand the example between or the meaning between CTC and the total remuneration. So that's very critical for you to understand that and then implement those. If you have any queries, definitely we can align that understanding of CTC. What's it is. Thank you, Srilal, to tell me about this is good. Okay, I'll go to the next slide. So let's cover this about the construction and BSW under OSH code. Very important that OSH looks after safety and working conditions, and on construction sites, like scaffoldings you have, and working at a height which you have, and your site housekeeping, etc. and all. And the welfare part is actually covered under a code on social security, which is the welfare of the workers, such workers, construction workers is there. So if a new building is constructed on an existing factory premise, some states have clarified that certain BSW provision may not apply because that is in the per act. But eh, the safest approach is now we will have a single license, and it will be applicable to that also. So, do you need a BSW registration, cess, and contractor? Everyone will fall under the same thing. So, ideally, the BSW should be done by the project owner, that is a bridge employer, and not the contractor. He must be having a total construction cost, and construction, mind you, it also includes fit outs from a raw office which is there. And the fit outs also come under construction, and you need to ensure that all the contractors you are doing, you collect and you pay the cess accordingly. That's very important. And I would suggest that instead of multiple contractors doing their own cess as per their work contract and all, it's a main employer or project owner should be actually paying the overall cess liability. Because in the end, you are applicable to that. That's what important. Sorry. Excuse me on this. I just dropped my headphones. All right. So I've given one more example on this particular principal versus contractor on construction sites. So project owner, principal employer will take up full project registration. He'll pay cess on total cost and ensure that this is the right and correct way of doing it and not the contractor wise. You may want to deal with the contractor separately on that. That's fine, about the cess to be paid, and that's fine. Contractors, they definitely need to take OSH license wherever applicable, ISMW or contract labor combine and everything. Ensure PFES and everything is in place. That's what it is. So this is the clear demarcation of what the project owner or business employer has to do, what a contractor has to do. So that's about it. Can you have the next slide, please? We already clarified this particular slide, so I'll skip this slide. So in the interest of time, this is the how the things which is covered. Yeah. So now let's look at the sector specific things. We already covered under BSW. We already covered under all other things about the OSH code. Now, these are sector specific. So, Mines Act was now subsumed as part of the mines now, which the focus point is safety, ventilation, rescue, especially of mine workers who work below the ground. Dock workers, lifting gear and cargo handling. This is a specific provision which is provided under earlier act. The same thing copies here also. So there is no much change in these chapters, be it mines, docks, motor transport, plantation, BD, or generalized, which is there already in the act or the individual act. Now they are all combined like a book binding, and it's part of the OSH code. Whatever changes were there are already specified, like you had the changes in BSW, interstate migrant worker, all the specific changes are already specified that. So that's a clear understanding with what it goes about it, right? Yeah. Next slide. So let's run through this each one slide about what it means. But we'll just skim through this. So it remains the same thing like duties of owner, ventilation, as I already told you, working hours and all special reason, which were there in mindset, it'll be the same thing now under OSH code. Next, please. For dock worker also, say for example, a container terminal accident due to uncertified lifting gear was there. It will be covered now under OSH code, and the welfare and information or whatever has to be done. It will be provided under this particular dock workers, but under OSH code. The common code is there, common benefits and everything is there. It will be now provided. They don't have to take a separate dock worker license and all. Next. Same for motor transport. Now, important is that all the contractors who are running their so-called transport of employees. Now, see, for example, now if you go for female working a night shift, you may have to provide a transport also, right? So those contractors, they need to be covered under this. If at all there's a license mentioned under this OSH code for motor transport undertaking, they may have to take that as well. So that's very important. And they need to ensure that all these things are there, including medical fitness tests for drivers, welfare facilities, all those things are there, which are very important, especially to monitor the fatigueness of the drivers. And those are the rules. I mean, they'll specify the rules and all. And it is bound on the principal employer to ensure, if at all you're taking any contractor who's coverable under motor transport, ensure the compliance is there under that also. Next slide. Plantation, exactly same, is just moving over to the OSH code. So it integrated pest management, efficient water usage and conservation. All those things are there, which is under Plantation Labor Act. Now it is covered under this as well in the main framework of OSH code. Next. Same for BD and SIGA. It's again another sector specific. So earlier BD cigar registration was very stringent, but the same it will cover under one OSH code itself, and you may have to take a OSH license for BD and cigar establishment. So there will be one license for or registration for BD and cigar establishment, and it will be the cigar establishment have the contractor, they have the interstate migrant workers, everything will just have one particular registration. So that's why I just wanted to share that. Largely journalists and audiovisual workers, the same act applied. The earlier act was there, and it is just now continuing here. Next slide. This is very important, which a lot of companies have told, and they just get confused between how many days worked is there. So the OSH code and other wage code as well. Typically, employees, they say they are 365 days working, and divided by 20, and 18 is the leaves which need to pay, or PLS to be paid to the employee, 18 days. So they directly, but actually that is not true. I'll give you the example another slide. Can you just go to the next slide? Typically, we may have how the 260 working days, as per my example I've given. I've kept 52 Sundays off, which is like a weekly off. I kept 10 public holidays, which is off also. And then there are 43 days which are there. It may happen that Saturday, 5 days working is there. Some CL or SL is taken by the employee, some unpaid employee. So remember one thing, when we talk about 20 days work performance, actually work performed by the employee, even if it is remote. If you're establishing that 1 day for every 20 days work performed, so over a given period of 1 year, the past year, how many total days yours, like a working days or work performed days? And that you divide by 20, and that is your rule. So typically, on a 6 day working, I'll tell you, 6 day working, it'll roughly come around on 15.5 to 16 days. And a 5 day working, which is my example here, it'll roughly come around 13 to 13, between 13 and 14. So most of the companies, if you're complying, if you have a 5 day working and you're just giving 14 days as a PL or a leave, you're still compliant. It's not non-compliant if you're not giving 18 and you're giving 14. Same for 6 days working. If you're giving leaves around 16, you're still compliant. I just wanted to clarify this very critical and important note here as far as this is, and not it's not 18 days at all. So that's very important to have you understand this whole logic about the weekly offs and public holidays and all. I hope I'm not going too fast and I can see some information. Okay. So long as people are saying thank you very much, it's all okay. All right. So let me give you, okay. Now, this is under OSH code, which is more on leaves. But mind you that every state specific leaves are separate, right? So it is not it is not a uniform CL structure. Every state has separate. Like there are some states in Karnataka and all, they have specified sick leave and casual leave separately. There are some states in Maharashtra, it is not, they have no sick leave or I mean there are no casual leave mentioned and all. So you need to maintain both the records. They need to implement both, right? There may be you're having a factory at one location and say shop administration or office at other location. You need to ensure that you still go state-wise uh, applying the leave logic. But the leave basic remains same 20 days, 1 day for every 20 days work performed. And that is very clear on this. All right. So that's what I wanted to share this information. Next slide. Welfare facilities. Again, I just want to rush to this side. Welfare is very critical. In fact, the same thing. Whether you are small or large manufacturing unit, you need to ensure, say, especially large manufacturing unit, the threshold of 300 employees and above, you need to ensure that canteen is there, creche is there, obligations are all maintained. Creche and the Maternity Benefit Act is very different, and that will be more than 50, which is there, which is as per Maternity Benefit Act, which is now under Code on Social Security, that will continue remaining the same until and unless there is a change. But if you're large manufacturing unit, you still need to give fresh and all those. Those things will all remain same. You need to ensure that you have tabs and hospital tabs and medical arrangements, which is there. As a bona fide employer, you need to do all those things, which is there. But that's a requirement of the codes as well. What welfare facility you can are you giving to the so-called worker or employee at your location? And that's what the minimum. And this includes your contractual, your FTC, your FTE, all such kind of people who are just working for you. That's the minimum expectation which the code is defining or the government is defining here. Next. Can you have the next slide, please? Now, this is I have already clarified in other three presentations about inspector come facilitator, very dual role. Uh, I've also clarified that how they will not just come uninformed. They need to be first giving a notice to you. First, they will ask the record which you need to upload in the portal. They will analyze it, and then they'll be doing a risk-based inspection. They will give a date to you. Right now, it typically happens in PF and ESIC, but now it is across all the labor code and all the acts under the labor codes. This will happen. Mind you, Shop and Association Act, the inspector still outside the whole limit. So shops and inspection inspectors may still come uninformed, and they still will be, unless and until the rules change depending upon state to state. So that risk is still already there. But here, as far as all the laws and compliance under labor codes, and especially OSH code, uh, it is more of going to be more of a facility. They'll give you a chance. You can also compound the offenses and comply. That's very important. So they will give you improvement advice and machining guard and all that. And if you're still non-compliant, then they will escalate to the penalties. This is going to be the role of the inspector come facilitator. I already clarified this risk base. Ensure that if you have a hazardous chemical plant, can you just go back to the slide? Hazardous chemical plant, it's very, very important that they're prone to inspection often, even if you may have submitted certain online records that everything is compliant and everything, all the logs are maintained properly, but still you'll be prone to more inspection than a small back office. So it all depends upon the risk profile and what are the incidents that happen. So ensure that you have to maintain all your incidents, all your things separately, whether it is shop and installation or a factory or hazardous a chemical plant or so and so. You'll have you may have a possibility of combined inspection across departments, but the way the OSH code and the way all labor codes are here, they want to combine everyone into one particular authority, and then those people will be coming for inspections. But your information, when you upload on the labor department website with these online records and all, will be accessible to all other departments of pertaining to your kind of work. So this is very, very critical of you to understand this. So while it is simplifying and while it is combining all the acts together, but it is also creating more risk for the organization to ensure that if they fail to comply, there's a huge penalty, though they will give you benefits and help to actually avoid those penalties, but the sword is going to be on your head. But don't worry, we are there to help you on this. The next. Yeah, so this is very important under penalties and compounding, which I have covered in other codes as well. There may be certain penalties which can be compounded, like in a minor first offense, where certain procedural compliance you've not done, or even if you're not paid many wages, they may just still compound it. They may not just do a criminal action against you. Okay, but see, generally all the contravention attract fines, and the fines are actually lakh plus in range. Okay, and repeat or serious violation will attract fines and even imprisonment, and this is very clearly established under code. So that is very important. And compensation in case of death or permanent disablement is addition to that, so that you need to ensure. However, if the first offense is there, even if the fines is there, they can compound 50% of the fine for you. So even if say 1 lakh rupees a fine is there, they'll have 50% of compounding there, but that will not absolve you to provide, like say many wages was there, one of the compounding offense, or many wage or salary not paid in time, those compounding offenses, or PF or DS is not paid properly. So you may do still provide that, but as far as penalty is concerned, you'll be compounded for say 50% of that, which you need to do it. That's very important. So the improvement notice will be given to you for you to fix this lapse. And during this lapse, if you're able to fix it very good, you'll be able to compound it very nice. Otherwise, they can go with full criminal case against you. That's very important. So understand that compounding doesn't mean that it is amnesty scheme. Okay, it's not an amnesty scheme at all. It still holds record for their violation, and repeat offenders or serious safety failures will not be a soft option anymore. So you can compound by one-time fire extinguisher or XYZ not met and all, but don't just build your compliance strategy around it. You need to ensure that you have precautions rather than just firefighting. Next slide. So these are just last couple of slides, and I presume that I've done much more earlier than what I had thought about it. But there's a cross linkages and transition checklist which you need to ensure. So OSH is cross with the wage code for the hours and overtime pay, which I already clarified. With Social Security, like BOCW, which is the welfare part about it, migrants and contract labor coverage. That's very important with the social security. The welfare part about it is in the social security code. Even the migrants and contract labor coverage for their benefits and the PF ESI will be under social security code. So that's a cross linkage. I record, yeah, any dispute, any accident, any safety issues are there, shift changes, it's all connected with this. So anything which happens under OSH for those workers and all, or for that matter, employees, the IR code will, take care of the disputes accordingly. So what you need to first of all, they see which kind of establishment you have. You need to see the sector tags. Just list your all existing licenses, where it is going to be expiring. Have a tracker on that. We can also help you in the tracker with our own portal, which is Compliant GMT or WeCheck. Uh, Review all the working hours, especially pan-India if you have companies and factories and establishments separately. Need to see which are your working hours, which are your leave which you're giving, and what are welfare you give. You need to just standardize those, and that's very important. Regularize your contract labor and ensure that migrant workers also now covered and need to audit them, and that's very critical. Ensure the documentation of migrant worker is there. And I told you the migrant worker is just not about uh, you getting from other state and all. It's on his own also if he come from other state, and so long as coming in the definition of worker, he will be covered under migrant worker, and you need to provide and maintain records accordingly and go for the registration license and all. Yeah. So rest, I'm sure that you subscribe to our, LinkedIn VCheck. We release a VTag on a weekly basis. You can go through LinkedIn and VTag is there. And monthly basis, we go and we publish Mojo, that is monthly journal, which give you all the information of the labor acts and compliance and everything. Apart from that, we also contemplating on doing one more series, like a more of a refresher course, maybe like another maybe a fortnight or something. Let's see how the all other codes are doing it and how the notifications have come. So 21st November was like whole earthquake, and then we are seeing all the after effects of that, and especially on the ESIC and other things which is already doing. We may also presume that PF will come very much soon in Jan and Feb with their own rules and all, including international worker and all. So stay in touch with us, and I hope, thank you very much that it was very clear. And this is what there are some people who are saying it's not clear. I would presume that you should go and run the presentation again. We will be uploading the presentation, all four parts, in our YouTube channel also very soon, and we'll give those links to you for you to share. Our objective is more to share with the fraternity what actually and simplify the whole compliance requirements for any of the organization. That's very important. I would like to thank specifically all my teammates, Dhanaswi and Niket and everyone here. Safka Sadaf is there, Archit, and whole team actually and Mudra is there, Sara is there, all people who have actually brought down all together to do this wonderful three-part series. And I thank you, everyone. More than 400 people have participated today to really see. I'm happy to take the questions next 15, 20 minutes. We'll try to address all the questions. But remember, if you have any questions, you please do write down on at your requirement labor coach at karmamgmd.com. And also, any help you need in terms of restructuring, in terms of understanding, in terms of seeing the salaries and all, we'll be soon releasing also about the overall scope of work additionally with every one of you, for you just to understand that what else we can do to help you out. Thank you so much.
Thank you all for joining us today and for your active engagement across our entire series, From Chaos to Code. We hope these sessions have helped you understand the changing landscape of India's labor framework and prepare your organization for a smooth and compliant transition. Special thanks to our speakers, Mr. Pratik and Ms. Sadaf, for their expertise and invaluable insights across all parts of our series. All the presentation decks and FAQs, including today's content, are available on our website, karmamgmt.com. And in case you have any more further queries and require assistance from us, please email us reach out to us on laborcodes@karmamgmt.com. Thank you once again for your time and participation. We wish you all a wonderful weekend ahead.